Good morning, this is your Kelso Report for Wednesday, March 7th, and I'm your host, Clark Kelso. Today we have cases dealing with appellate jurisdiction, immigration law, consumer protection in the telecommunications industry, and an anti-SLAPP to round things out. We begin with appellate jurisdiction in the Ninth Circuit. As we all know, the federal courts follow the final judgment rule pursuant to 28 U.S.C. section 1291. Which pretty narrowly limits the collateral orders that are appealable during pretrial and trial proceedings. In Klestat and Winters versus Cangelosi, the Ninth Circuit considered the appealability of a sanctions order that was directed at one of the parties in the context of a bankruptcy proceeding. The general rule is that sanctions imposed against a party in civil litigation are collateral orders that are not immediately appealable. This is usually because the reason for the sanctions is often related to the underlying merits of the lawsuit, as was true in the case before the Ninth Circuit. And until those merits are appealed, the derivative sanctions order cannot really be fully reviewed. However, the bankruptcy context arguably changes things, because appeals from the district court sitting as the bankruptcy appellate panel or a district court hearing an appeal from a bankruptcy court fall under a different appellate jurisdiction statute, which has been interpreted more broadly than the 1291 general appellate jurisdiction statute. But in this particular case, the district court was itself sitting in bankruptcy, and it was not reviewing a bankruptcy court's decision or sitting as the appellate panel. And in that procedural context, Section 1291 and its narrower approach to the appealability of collateral orders applies. So, the panel dismissed the appeal for lack of jurisdiction. Next, we have an immigration law case. The Board of Immigration Appeals had previously heard this particular petitioner's claim that he was likely to be tortured if returned to Nigeria, because of his religious beliefs in preferring Christianity to Islam. And the board had previously granted him deferral from removal under the Convention Against Torture. 4 years later, though, and after he had once left the country, the U.S. government reinstituted removal proceedings, but this time denied him deferral. The Ninth Circuit held that the doctrine of collateral estoppel applied in these circumstances to bar the government from relitigating the fact matters and conclusions drawn from those facts in the prior proceeding. The government, of course, could introduce evidence regarding new circumstances, if any, in Nigeria, and any changes in the petitioner's status that might relate to those new circumstances. But the government must use the prior findings as a baseline in this new proceeding. Having decided the circumstances justified deferral 4 years ago, the government may not simply reverse itself on those already litigated facts and conclusions. Next, we turn to state courts and consumer protection in the telecommunications industry. Now, it is not often that we see a court simply refuse to decide an issue because, in its view, the issue would be better resolved by the legislature or an administrative agency. Absent legislation or regulatory action, courts will often just do their best to fill the gaps in the law as best they can using their traditional common law tools. That's what they're there for, is to decide what the law is. But in Willard versus AT&T Communications of California, the Second District panel held that it would abstain from deciding whether the fees charged by AT&T for a non-published or unlisted telephone number were unconscionably high. These services result in a telephone number not being listed in the white pages or included in 411 listings. AT&T charged $1.25 per month for non-published and $1 a month for unlisted. According to the complaint, these services generate $14 million in revenue and are virtually costless for AT&T to implement. The Second District noted that the Public Utilities Commission had determined in 2006 that competitive market conditions support free market pricing for these services. And the court was concerned that trying to determine whether these fees were unconscionable would drag it into complex considerations of economic and regulatory policy that it was not well suited to deciding absent further guidance from the legislature or a regulatory agency. So the court affirmed dismissal of the complaint with prejudice, holding we just can't decide. Now, this is conceptually a very interesting decision with a good dissent by Justice Moss, who says, wait a minute, we have to decide. And it raises important questions about the competency of the courts and the relation between legislative, administrative, regulatory, and judicial functions. So, I would not be surprised to see the California Supreme Court grant review. Not because the result of the case is wrong, I don't think $1 or $1.25 is unconscionable, but because the reasoning of the decision is potentially far-reaching and is certainly provocative. And besides, the case would be a lot more fun than the run-of-the-mill death penalty case that occupies so much of our High Court's time. We close today with an anti-SLAPP motion in Nesson versus Northern Inyo County Local Hospital District. Here, the hospital had summarily terminated a radiologist's privileges at the hospital following a dispute about the doctor's behavior towards other staff members. The doctor responded by filing a lawsuit alleging breach of contract, retaliation, and discrimination. So, the hospital filed an anti-SLAPP motion, and the Superior Court held that the plaintiff's claims were properly subject to the anti-SLAPP statute and that the plaintiff could not establish a reasonable probability of prevailing. The Fourth District affirmed, holding first that the summary termination process was in the context of the hospital's statutorily required peer review process, which, under the anti-SLAPP statute, constitutes an official proceeding. So the anti-SLAPP statute applies. Second, the court held that the plaintiff had utterly failed to exhaust his administrative and judicial remedies before filing his lawsuit. That's a no-no. And third, therefore, the plaintiff did not establish a probability of prevailing on the merits. Plaintiff's action is dismissed. And that's it for today's Kelso Report. Have a great day in the law.